Good afternoon, everyone. We're going to wait just until everyone can join in before we begin. All right, so it's one after. We will begin. And good afternoon, everyone, and welcome to CAI Canada's webinar. We are pleased that you have taken the time to join us this afternoon for an important discussion on condo chargebacks, the pitfalls and best practices. Before I introduce today's panelists, I'd like to go through a few housekeeping notes and announcements. You will notice that the chat feature on the Zoom platform has been disabled. We do ask that you participate by posing any questions you may have in the Q&A feature. We will do our best to answer all questions throughout the session. Today's session has been approved by the CMRAO for 1 CPE credit. Our registration list will be provided directly to the CMRAO after today's session, so you will not receive or need a separate certificate. And finally, if you have not already registered for the upcoming CAI Canada annual conference taking place on Tuesday, April 14th at Parkview Manor in Toronto, I encourage you to do so. We have a fabulous lineup of great sessions and presenters, along with a one-day trade show. You can register online at caicanada.com. So without further ado, I'd like to introduce today's panel. Myself, my name is Jake Fine. I am a partner with Lash Condo Law, and I'll be moderating today's session. Joining me today is my partner at Lash Condo Law, Natalia Polis, Mark Balla, the Vice President of Policy Programs and Dispute Resolution and Interim Deputy Registrar at the Condominium Authority of Ontario, and Chris Jonay, a Regional Manager at Haircoda Condominium Services. So once again, I'd like to welcome you all, and let's begin today's discussion. I want to first start off with Chris. Now, Chris, why don't you take us through the manager's perspective as we deal with chargebacks and unit owners?
Thank you, Jake, and thank you everybody for joining. First, I want to thank you, the CAI Canada, for organizing today's session, as chargeback is something that we definitely see in the regular practice. And if you've been a condominium manager long enough, you know that chargebacks are one of those topics that can quickly turn into a dispute if they're not handled properly. Jake, if we can go to the first slide. Before we get into the chargebacks, I thought I'd share something that many managers in the room here might relate to. These are probably the top 5 things that condominium managers hear every week. The guy from the office, I always love him. Management should pay for that. My neighbor is making noise again. What are you going to do about it? My fridge is leaking, but it's definitely not my problem. My maintenance fees should cover that. And one of my personal favorite is that the last manager never did it this way. And if we're honest, most chargeback disputes usually start somewhere in this list. One of the interesting things about being a condominium manager as well is that we're expected to know a little bit about everything. We're supposed to be plumbers, we're supposed to be engineers, we're supposed to be lawyers, accounting, mediators, IT specialists, and sometimes even psychologists. And if or when that pipe bursts at 2 a.m. in the morning, we're the first one who received that phone call. And somehow we're expected to immediately know why it happened, who caused it, and who should pay for it before we even had our morning coffee. Another thing that, important thing that we like to clarify is that when discussing about chargeback is that chargebacks are not fines. Chargebacks simply allow the condominium corporation to recover an actual cost from an incident that occurred because of something that happened from an owner or a resident in the building. So the purpose of the chargeback is not about punishment. It's about responsibility and fairness. So if the corporation incurs a cost because of the particular unit, that cost should be covered by that particular unit and not be absorbed by the owners through the common element fees. And let's be honest, if a condominium corporation actually had the power to fine owners, a lot of the board would have solved probably the budget issues. The budgets will not be increasing by 5% or 6%, but hey, let's reduce it to 2% because the rest is going to be fines. And the managers would have solved the issues that we have with some of the bad tenants, where we keep arguing with them for regular disputes. We would just start issuing them fines. But that's not how the legislation works. And this is where we come in as managers. And I say that there's a lot of misinformation in industry, and I've countered occasions where a condo owner usually say, my condo fined me $800 for some violation or trying to recover a little bit of a chargeback. Is this allowed? And sometimes the confusion starts when how we as managers start explaining things to our boards and to our residents. I often hear some managers tell the board, after the 3 warning letters or 3 letters that I'm trying to collect the chargeback, I'll have the lawyer fine the unit owner $800 and that's going to be added to the chargeback as a fine or whatever that legal fee preparing that letter is. That is not correct. The corporation can recover the actual enforcement costs if legal action is required. But again, that is not a fine. And using the word fine, it creates the wrong expectations for the owners. You can go to the next slide. Another big reason that chargebacks become dispute is that owners often don't understand the responsibilities on the condominium. They assume that the corporation will cover everything inside and outside the unit. But that's not the case. Again, we refer always to the declaration and standard unit bylaw that we have in place, but I'm going to take an example. Some condo corporation declaration states that owner responsibilities are appliances, plumbing fixtures, personal belongings, and cabinets. And the corporation is responsible for drywall, window, unit entry, again, depending always on the declaration. Now we have this information, and how do we transfer this to our owners? Because this is great, the declaration is long, but a lot of owners don't read it. Jake, if you can, next slide. And this is where I like to actually, it's play a little bit of a joke with the board, the brainwashing joke. Again, not brainwashing in the bad way, but we need to constantly educate our owners about how condominium living actually work. Because if this is the first time that an owner hears about the responsibilities after water is drip into the unit below, it's already a dispute. And the conversation usually starts with, why am I paying for this? One simple tool I always recommend managers implementing is responsibility chart based on, again, the declaration bylaw and the standard unit definition that you have. Something that clearly explains the owner's responsibilities and the corporation's responsibilities. Again, don't forget that these are repair and maintenance, standard repair and maintenance, and responsibility after an insurance loss has occurred. And once you prepare these charts, let's start sharing this information regularly with the owners with slides like know your condo, or did you know if this happened, this is what you're responsible for. And start posting these slides in bulletin boards, newsletters, email updates, or if you use a residential portal, just keep sending it out to your owners. Over time, owners begin to understand their responsibilities and chargeback conversation become much easier. Next slide. Another reality is that of condo land is that managers have their hands full. I mean, right now we start talking manager needs to know how to be a plumber, an engineer, we do this, do that. So buildings are becoming more complex, technology is advancing, and compliance requirements continue to grow. So how do we stay on top of this? How do we manage this? And I always rely back to start using templates, start putting in place procedures and standard documentation. You can have your incident report template, the chargeback letter, investigation procedures, responsibility charts, and communication templates. How will this help you? Most of the security companies there come with incident report template. but let's make that site specific and that works in our benefit. Let's have develop an incident report template where security can use and write the incidents in a way that relates directly to your chargeback letter. Once you create that chargeback letter template, you add those portions of the declaration, and then you copy that portion of the incident report. So it's a copy paste and it's something easier for you. And then on top of it, start putting in place investigation procedures. Because if, for example, all of a sudden maybe is a small drip or something in the building that a security guard or somebody can turn off the water, put in place an investigation procedure that they can do it without having to call an after-hour plumbing company or restoration company that will cause you an arm and a leg, and then you'll have to go back and charge the owner. So and then responsibility charts that owners understand who's responsible for what in case if you end up making that call. Communication template always with the owners, because the first thing that you need to do after something is happening, even if you don't know the reason why, you always send that communication to the owner and let them know what's happening, and you are on top of it and you're investigating further, and further communication is to follow. And always remember now, because we have to work with deadlines as well. Because if a chargeback happened, yes, we do have that 90 days to register the lien, but let's start putting some deadlines on ourselves, because first letter is to be sent within the 10 days or 20 days or whatever it is. And once the 60 days has reached, make sure that all what you tried as a manager to do, you have done it, and then that file can be passed down to your legal counsel. These tools will allow always the manager to operate consistently and efficiently. It's also important for the board to understand that managers are not investigators or engineers. We do not determine the technical cause of the failure. We rely on the professional opinions of the plumbers, engineers, restoration company, or insurance adjusters. But you always need to remember that a manager should always be able to recognize a weak report when something is missing. We may not determine the source of the issue, but we should be able to identify a weak report or an incompleted report when we see one. I'm sure many managers here have seen reports like a plumber attending the unit and the report simply says, investigated unit 202 pipe is leaking, and that's it. At this point, as a manager, we're thinking, thank you. That really clears things up. And we're already one step back. So what are we supposed to do? We rather communicate with the owner at this point that we're still investigating the source of the leak, and we'll more communication is to follow. And we follow up with a plumbing company or whoever completed that investigation, because we need to make sure that we get the reports clearly. And if we take this report and go to the board and tell the board we're going to proceed with a chargeback because we know the reason why, and 30 days after all the repairs and everything has been done, we send a chargeback letter to the owner saying, here's $12,000 or $13,000. That owner will most likely dispute it. And if I take that file, because I'm pretty sure I'm not going to be able to collect that chargeback, send it to our legal counsel is going to flag it. It's going to say that report it's not sufficient for us to collect that chargeback. We continue fighting, and then we're going to end up in one of those CAT cases where owner versus corporation, and then the owner is going to be the one who wins because we as managers didn't do our job to collect the right information. Always remember that if a report doesn't explain the 5W questions that we have learned in school, where the leak originated, what failed, why it failed, who was responsible, and when did it happen, we are not going to be able to collect those chargebacks. So chargebacks should always be supported by these documentation, strong communication with the owners, professional reports, incident documentation, contractor invoices, and proper investigation. Good documentation will protect the corporation, the board, the manager, and even the owner if they want to make a claim with their insurance. So when we talk about best practice for chargeback, it really comes down to four things. Educate your owners early, use templates and procedures, rely on professional documentations, and always remember, chargebacks are not fine. Because at the end of the day, good condominium management isn't just about fixing a problem. It's about preventing the next dispute before it even starts. Thank you.
Thank you very much, Chris. Now, from the manager's perspective, how do you justify and communicate chargeback costs to owners when they believe that the amount is too high?
That's a great question. I mean, uh, if let's say in most cases the repair cost or of drywall or something, they're pretty standard throughout the companies, and because that's something that you schedule, you get the three. I'm hoping that most of the managers get those three quotes and do that chart to make sure that they're picking the most reasonable one. But mostly of these disputes come in when they go to the engineers or the plumbers report, because those reports may go, or those charges may go from around $300 to $1,500 or $2,000. But this is where we say we go back to the procedures, because we need to know if we actually need to make that call to the plumbing company at the middle of the night and pay the overtime charges, and how long that investigation took place. So, for example, I'm just going to say, if I issue a chargeback of $900 or $1,000 to a unit on the eighth floor, and they come in and say, well, our plumber would have charged us $250, maybe that documentation or that invoice that we present to the owners, it needs to have a little bit more details. Well, the investigation started on the second floor and it took time and material all the way up once you went to reach to the eighth floor. That's the timing that you're paying for it. So it's not just a simple phone call, it's the hours that the company put in. So these are the cases where you start explaining to the owners that it's not just a simple phone call, but is what work has been done and took time to determine the source of the leak. And another thing that I always say, it's let's not go too many on technicalities with the reports. We keep it simple. This is the source of the leak. This is how much we took to investigate, and this is the going rate per hour.
That's great. And I think to your point that you made several times throughout your presentation, proper documentation is crucial once you get to that chargeback stage so that the corporation can actually justify the cost that is being charged back. So thank you very much, Chris. We're now going to move on to our next topic, which I think is everyone's favorite, insurance chargebacks. So with that, I'm going to turn the floor over to Natalia.
Great. Thanks, Jake. And thanks again, CAI, for hosting this webinar. And thank you for everyone who's in attendance with us this afternoon. So as Jake mentioned, I will be touching on everyone's favorite topic, other than chargebacks relating to compliance letters, which is Section 105 of the Condominium Act. Chris went through great detail on the manager's perspective on certain chargebacks that do relate to, let's say, plumbing issues, floods, etc. I'm going to go into more of the actual process, the legal framework, and some best practices to avoid the common pitfalls when charging back repair costs or insurance deductibles to unit owners from a lawyer's perspective. So first and foremost, what is a chargeback? I know a lot of people here are probably like, this is an easy question. And as Chris mentioned, this is not a fine. A chargeback in this context is a recovery of costs that a condominium incurred due to repairing damage due to an insurable event. So a flood or a fire, or the insurance deductible that a corporation had to pay once they remediate a unit or get their insurer to assist with remediating a unit due to insurable damage. These costs are ultimately added to the owner's common expenses, and they are enforceable just like any other common expense arrears. So once, as Chris gave us a process, a chargeback notice is provided, a deadline is stipulated for an owner to pay the chargeback, then the corporation, if it's left unpaid, can take legal action. And that could include a lien being registered on title to the unit. So this is an extremely important tool for condominium corporations so they don't bear the financial burden of repairing insurable damage caused by a resident's actions, or as we'll see later, if a unit just was the source of insurable damage. So Jake, if you could go to the next slide, please. So Section 105, which oftentimes is the most difficult section to explain at an owner's meeting, especially if you're trying to propose a standard unit bylaw or an insurance deductible bylaw, a lot of owners don't understand exactly how complex a condominium's insurance is. So, under the Condominium Act, a corporation, as we know, is required to maintain insurance for both the common elements and certain portions of the units. Under Section 105 of the Condominium Act, it provides that if damage occurs to a unit and the cause of that damage is an act or omission of an owner or a lessee or someone residing in the unit with the owner's knowledge, so basically anything that the owner would have responsibility for, the cost of repairing that damage can be charged back to the owner. So this is also qualified and limited to the lesser of the actual costs of the repairs and the deductible limit in the corporation's insurance policy. So to give you an example of how Section 105 works, if, let's say, Unit A, the source unit, they let their bathtub overflow, they had too many glasses of wine and fell asleep, and they damage the standard unit components of their unit, or at least some of them. Under this section, the condominium corporation would be obligated to repair the standard unit components of that damaged unit from this insurable event, and that would be limited to either the cost of the repairs or the deductible. So let's say in the same example, the cost of the repairs are $5,000 and the corporation's insurance deductible for floods is $25,000. The condo corporation can only charge back up to the $5,000, so the repair costs. On the flip side, if the cost is $40,000, and again, the insurance deductible for floods is still $25,000, the corporation can only charge the unit up to the $25,000 deductible. They can't charge the excess up to the 40 that were the repair costs. So if you could go to the next slide, Jake. So there are some key elements when looking at Section 105. There's basically 3 points that a condominium corporation has to prove. The first is quite obvious, that damage has actually occurred. So the corporation has to prove that there was damage to the unit. The second is that that damage was insurable. So that damage is something that would typically be covered under the corporation's insurance policy. So the ones that we typically see are water damage, so flooding, and damage from fires. Sometimes it isn't as obvious whether or not something is considered insurable damage. And that's when, as Chris mentioned earlier, you do want to consult your professionals. Whether or not you're making an insurance claim through your own corporation's insurance, consult with your insurer to make sure that this was in fact an insurable event that we have coverage for. Otherwise, the Section 105 analysis wouldn't be applicable. And finally, under Section 105, you do have to prove some kind of causation. So you have to prove that the damage was actually caused by an act or omission of the owner or someone residing in their unit or someone that they're responsible for. So those are the 2 operative words here, an act or an omission. So Jake, if we could go to the, oh, perfect, you're ahead of me there. Okay, so what does an act or omission mean? So when we talk about an act or omission, we're talking about 2 different types of behaviors that may cause the damage. An act refers to positive conduct. So it's an individual actively doing something. So for example, as we just mentioned, if someone leaves their bathtub overflowing, that's an act. If someone lights a cigarette and lights their unit on fire, that's also an act. An omission is oftentimes more difficult to prove, and it requires a failure to act. So such things as failing to maintain a pipe that you are responsible for as a unit owner under your declaration. If it's proven that you fail to maintain this pipe that you're ultimately responsible as a unit owner, that could constitute an omission and fall under the Section 105 analysis. The omission can also include things like clear negligence, carelessness, or a failure to make the repair, as I mentioned, that the unit owner would be responsible for. So when we look at Section 105 and insurable damage, it's impossible not to look at the standard unit interaction. So the critical point to know is that the interaction between Section 105 and the standard unit is that the standard unit defines what portion of the unit is the corporation's responsibility to repair after insurable damage. So we have some older corporations that do not have a standard unit bylaw, do not even have a developer's original finishes schedule, or any sort of document that defines what the standard unit includes. In those circumstances, it becomes extremely difficult to ascertain what components of a unit the corporation would be responsible for to repair after insurable damage, and what components a condo corporation or the unit owner, is responsible for after insurable damage. So just to start off the best practices for this portion of the presentation, it's imperative if your corporation does not have a standard unit bylaw in place to take steps to put that in place. Arguably, it's the most important bylaw that does safeguard the corporation and really makes a financial difference in terms of cost savings from having to pay for insurable events. Section 105, though, applies regardless whether or not there is a standard unit defined. So this does have implications with respect to insurance claims and how the deductible can be allocated. Okay, next slide, Jake. Okay, so the insurance deductibles themselves. So how could the insurance deductible or the repair costs be charged back to a unit owner? So the first is, of course, the Section 105 analysis. And this, again, requires that there's damage. The damage is an insurable damage, and the damage was caused through an act or omission, and then the corporation could charge back the lesser of the cost of the repairs and the deductible limit. In this case, as I mentioned, you have to prove causation. You have to prove that there was an act or omission, and how we prove that, I'll get into that a little bit later on in the presentation. The second is through an insurance deductible bylaw. So under the Condominium Act, although there was some talks and the legislation was going to change to remove this ability, but thankfully, I think that's one of the provisions that fell by the wayside with all the delays. An insurance deductible bylaw allows the corporation to extend the circumstances to which the corporation can charge back that lesser of the repair cost and the insurance deductible limit. Oftentimes, these bylaws will only require that the corporation prove that it was this particular unit that was the source unit that caused the damage, and the damage was not caused by an act or omission of the corporation or one of its agents. So it does take away that need to really prove causation through an act or omission of the unit owner or someone that the unit owner is responsible for. It is a lot simpler to use a standard unit bylaw that extends these circumstances to charge back owners for these costs. Oftentimes in a standard unit bylaw situation, we do see as well that the corporation could charge back not only the repair cost for the source unit that's damaged, but also the repair cost for common elements that are damaged, as well as other units. So under Section 105, you could only charge back the repair costs of the unit that caused the damage essentially to itself. Under the insurance deductible bylaws, you can extend those circumstances. And let's say, again, same example with the bathtub overflowing. Unit A not only causes damage to itself, but also to the common elements and other units. In that circumstance, if the bylaw extends the ability for the corporation to charge back these costs, you could also recover for the repair costs, again, only up to the deductible limit for damage to the common elements and to other units. Under just a strict Section 105 analysis, you cannot extend those circumstances. And that is a common pitfall we do see. A lot of managers or boards are trying to charge back all of the costs, first and foremost, of an insurable event, but then also costs relating to fixing other units and the common elements when they do not have a bylaw or insurance deductible provisions in their existing documentation that allows them to do this.
So Natalia, so what you're saying is without an insurance deductible bylaw, if an individual falls asleep from too many glasses of wine and spills, their bathtub overflows and causes damage to their unit and units 20 floors down,
Yes.
the corporation can only charge back the damage that they caused to their own unit?
Yes.
Wow. So that is a very important bylaw then.
Yes, the insurance deductible bylaw and the standard unit bylaw go hand in hand as the most important bylaws you could possibly pass in your corporation. So going to the next slide, and I think Chris touched on a lot of these points, but this is when a file like this lands on our desks and we're taking these enforcement steps to collect a chargeback, this is what we love to see. So we love to see the actual investigation reports from the incidents. And as Chris mentioned, detail is important. We want to see that these reports actually have evidence and proof, whether that's through videos, photos, actual detailed written reports from the experts to determine the cause of the damage and the responsibility of who caused the damage. The second is the repair invoices. So the corporation would get the repair invoices. And we want to see those also being as detailed as possible to show that, look, these are the standard unit components that were fixed under these repair invoices. The next, as Chris also went over, is providing notice to the owner. So oftentimes I've seen notices that are very nominal saying, look, there was a flood in your unit. We had to repair this. This is how much you're required to pay. And the unit owner, not understanding the implications of Section 105, the standard unit bylaw, the insurance deductible bylaw, automatically says, wait, hold on a second. I don't understand this. I'm not paying this. So explaining to the owners, why are they responsible? Why is this amount being charged? And providing them with the supporting documentation. Next is once notice is provided and you give that deadline, a lot of times you'll see owners asking for an extension or asking, oh, can I pay it next month or the month after? While it is good to be lenient and reasonable with unit owners and when they should pay things, the problem is when we want to register a lien and when that time starts ticking. So while leniency is all great and fine, you want to make sure that you don't surpass that lien deadline and you can't actually recover through lien registration. Okay, so the next common pitfalls. So I know we went over some of this, but first and foremost, insufficient evidence of causation. So if you need to prove causation, and frankly, I would have this for both someone that has a standard unit bylaw in their corporation and an insurance deductible bylaw, as well as a corporation that's just relying on the Section 105 analysis. In these circumstances, you want to have the expert go in there and actually have evidence of the causation. Second is charging back non-recoverable costs. So I've heard managers say before to me, well, you know what, we've always been charging back all of the costs, notwithstanding it's over the deductible limit or that they don't have an insurance deductible bylaw in place. And they say, we've never had an issue. This is the first time. Well, yes, it's the first time now that someone's noticed and is now challenging it. So we want to make sure that you're charging back only costs that you legally can charge back. Next is the failure to follow the proper process. So skipping steps, failing to provide notice or proper communication to the unit owner, that oftentimes is detrimental to the condominium corporation. Fourth is delayed lien registration. So as I mentioned earlier, while you want to be lenient, you want to be reasonable and understanding to unit owners that may be trying to get the funding to pay for a chargeback, you have to keep in mind that you have a certain deadline to register a lien on title. Otherwise, you may lose that ability. And last but not least, lack of clear documentation. So Chris went over this in great detail, that you want that detailed documentation. That's critical when you want to charge back costs and be successful in doing so if a unit owner does challenge them. So last but not least, some of the best practices to wrap this up. So 1, maintain strong incident reporting procedures. 2, use the professionals when needed. Sometimes calling your superintendent, who oftentimes is way more advanced and knows a lot more about how condos work, how the plumbing works, etc., than an actual plumber or somewhat an engineer. Sometimes their word seems to be in favor of the corporation. It's not so much as a third-party expert. So you want to get that professional in to provide that expert opinions. And if, when in doubt about what you can and cannot charge back to a unit owner, consult your legal counsel. 3 is communicate clearly with the owners. Transparency, clear communication, and also actually explaining things to unit owners in layman's terms oftentimes goes a long way. 4th is document everything. Keep thorough records of all the steps, all the evidence, the notices, the communications that you've provided to the unit owner or the resident if it's a tenanted unit. And 5, review your governing documents regularly and ensure that your bylaws and your declaration are up to date and they reflect current practices and legal requirements. You want to make sure you have that standard unit bylaw in place, you have that insurance deductible bylaw in place, and you have the provisions that allow you to charge back these costs to the unit owners.
Thank you very much, Natalia. We're now going to shift gears and hear about legal chargebacks and how the CAT is dealing with those. So Mark, the floor is yours.
Thanks, Jake, and thanks CAI Canada for having me here for this webinar, although I must say it is difficult to follow up Natalia, so I'll do my best here. I'm going to be talking about specifically legal chargebacks, legal cost recovery. Before I do, I just wanted to pick up on something that Chris had mentioned around the concept of fines and how it's problematic to look at chargebacks as fines here in Ontario. British Columbia has a whole regime for fines in that province. They can do in their stratas over there. We don't have it that way here. And I think it's really important, given the misunderstandings that Chris mentioned, because the mentality behind fining somebody is penalizing them for what they did. But chargebacks aren't about penalizing, it's about cost recovery. It's about the condominium was required to spend this money, and the condominium is now trying to get reimbursed, made whole for that expense. And I think it's really important to have that straight as we look at this, because there are common pitfalls in looking at chargebacks as fines or ways to penalize people. So with respect to chargeback for legal costs, what that typically looks like is the condominium corporation has their lawyer write a letter. The cost of writing that letter is borne by the condo. They argue they wouldn't be responsible for that cost if it wasn't for the behavior that gave rise, so they seek recovery. Condominium Act can allow for it, but as the prior presenter said, really essential to take a look at your governing documents because you need to have indemnification provisions there, most commonly in declarations, but it's good to be on top of what you have there. With respect to legal costs, recent cases have determined that compliance-related legal costs require either a CAT or court approval to be charged back as common expenses. So the idea of charging back legal costs that the corporation pays to their lawyer, typically as a best practice to do that, you should have some kind of verification from a court or tribunal to be able to go ahead and do that. Next slide, please, Jake. Perhaps most importantly here, from the best practices that have been shared, is that the concept of charging back should never come as a surprise to an owner. The best practice recommendation is to communicate early and often, to offer key details and reasonable solutions, like take part in offering solutions to how the issue can be addressed, and allow time for resolution. You don't want to end up in a situation where you're seen to be overly aggressive by not providing enough time for somebody to actually actively take reasonable steps to address a matter. Important to also explain the corporation's escalation process. So each step that continues on in the chargeback journey doesn't take the owner by surprise, that they're fair warning that this is going to happen, and to also ensure that you document your efforts and your interactions. One piece I'd like to highlight around the corporation's escalation process in terms of the best practice, it's important that the corporation is consistent, that no matter who the owner is, no matter who is responsible for the behavior that's concerning, they're all going to be treated the same way, whether they're seen as a friend to the board or they're seen as somebody who's a regular problem creator. They're treated equally by way of a policy and a process that is pursued the same way for everybody. And of course, you may, in certain situations, if you have somebody who's a repeat violator, get professional advice to do something different. But just as a general process framework, idea to have set policy and process that's carried out the same way in all locations, so there's no special behavior or treatment of an individual. Next slide, please. So the general message is collaborate first. Always try to work with the person to see what might be able to be done to resolve an issue. avoid the incurrence of unnecessary legal costs, additional time, or measures that might be seen to escalate the matter prematurely. Essentially, what we've been told and what's reflected in the various decisions is a bad look for a condominium corporation to be seen as being heavy-handed, right? The point that Chris had mentioned about education, these practices about allowing people an opportunity to understand proactively, to reach out and to try to see if it's possible to address an issue. If an issue remains and there needs to be an escalation, a condominium corporation with the right type of provisions may be able to charge back costs as common expenses that allow for the lienable right that Natalia had mentioned. But not all costs are automatically recoverable. So it's important to be really clear on what your governing documents say and what the situation is. How it looks in practice is the issuance of formal compliance or legal notices, engaging counsel when appropriate, and ensure all steps and costs are well documented. It's not typically a good idea to have the very first engagement be a legal letter asking for money back. Usually initial communications before matters escalate to start incurring costs can be really helpful and important. And as we've seen, it's essential to make sure that you've taken reasonable steps to investigate the matter to ensure that you have everything appropriately documented if you have to go down this path. The next slide, we've talked about it a little bit, so I'm not going to go on for too long if an owner can't pay. But I just do want to reiterate what was said by Chris and Natalia around, look, if you're going to charge us back as a common expense from the time that it's technically due, you have 3 months to lien. So it's really important to be thoughtful around when that payment deadline takes place. And we've heard stories about condos working with their legal counsel to possibly try to get creative around when those deadlines are, such as trying to arrange some form of payment plan or something along those lines, keeping that timeline in mind. Because if an owner is all ready to pay but needs a little bit of time, and you set your deadline for the chargeback in one where you have to lien before they can pay, you're kind of putting yourself and them in a tough spot. So it can be important to have some of those discussions with professionals. Think about some creative ways to be able to allow people to bring themselves into compliance as far as that goes. The CAT does have jurisdiction over some elements of chargebacks, but unfortunately where it gets a little bit complicated is it's not all. All right, so basically it really depends on the issue that leads to the chargeback. So if the issue falls under the jurisdiction of the tribunal, then you may be able to go to the tribunal to look to uphold a chargeback to allow you to collect it as a common expense. Otherwise, you might have to go to the Superior Court of Justice or else through private mediation and arbitration. So the tribunal has jurisdiction over nuisances, noise, vibration, smoke, vapor, light, odor, parking, storage, vehicles, pets, animals, and certain types of harassment and nuisance that fall within the governing documents of a particular condominium, condominium records, and compliance with settlement agreements that have previously come to the tribunal. There was in 2022 a practice direction released by the tribunal chair in Darling, which is still available online. And in the next slide, there's a QR code if you want to check it out there. And it provides an overview of some of the approaches that the tribunal has taken around awarding costs. If you wouldn't mind going to the next slide, please. Jake.
Mark, just before we do that, can you give just a quick example of how a chargeback related to one of these items may fall within the CAT's jurisdiction and one that would not?
I actually have 2 cases I'm going to speak about that highlight both examples. So if you don't mind, let me just say the quick practice direction piece, and then we'll get into that if that's okay. It's a great question. Thank you. So essentially, what this practice direction confirms for us is that some of the relevant factors that the tribunal adjudicators will consider around awarding costs are the nature and the complexity of the case. Were the costs incurred proportionally appropriate for the significance of the matter, or does it seem to be a bit much? Usually it's about reasonability as far as that goes. The extent that costs were reasonably incurred. Right? Like, do these costs have to be incurred by the condominium corporation in this particular matter, or was it excessive, premature, etc.? The conduct of the parties can play a big factor. If attempts were made to resolve the issue, the collaborative first mindset, trying to work with the individual before escalating can go a long way, not only in trying to be proactive and address situations earlier on to avoid time and costs, but also when it comes time to try to seek recovery, showing that you did attempt to not have it escalate can be really helpful. And then, of course, a recurrent theme in all of this is the condominium's governing documents. What exactly the provisions say there can be really important as far as that goes. Next slide, please. So what's outside of the tribunal's jurisdiction, and again, to Jake's question, I'm going to give you an example of a case that was outside of the jurisdiction and a case that was within. But if you're in a situation that doesn't fall into the tribunal's jurisdiction, you're looking at either having to go to private mediation, arbitration, or court as far as that goes. So it is really important as you embark on this process is to get an understanding of what your path for dispute resolution is. Is this a matter that you might be able to take to the tribunal? Do you need to go another route? It can be really important to chart that out, both in terms of the escalation process and being clear about how that works, but also so you have a handle of what you're getting yourself involved in and what that path would look like. The cost, the timing, the impact, all are factors as well, and we can get into that a little bit, but let me just share the two cases that I wanted to talk about. So the first case I wanted to mention is Garecki's and Middlesex Condominium Corporation number 234. It was released on March 12th, which was a heck of a birthday present for me to have a decision out on this at this time, preparing for this webinar. But this was a dismissal order. So essentially, a unit owner went to the tribunal to take an issue with the chargeback that Middlesex Condominium Corporation 234 charged them related to downspout and drainage work. Okay, so downspout and drainage work is a maintenance and repair matter, and maintenance and repair issues are not currently within the tribunal's jurisdiction. So when this owner brought this application to the tribunal itself, through active adjudication, through screening process at the application stage, flagged, wait a second, this owner is trying to bring this case about something that is outside of the tribunal's jurisdiction. So it dismissed the case. All right. It wasn't a long, drawn-out motion with lots of submissions having to be made by the condominium corporation. This is a tribunal being proactive around its jurisdiction and not allowing a case to go further along the tribunal's process that was clearly outside of the tribunal's jurisdiction. All right, so because we're talking about repairs and maintenance, which is a common one that we see around chargebacks that fall outside of the tribunal's jurisdiction, to answer Jake's question, that's a good example of the type of chargeback matter that you cannot pursue through the Condominium Authority Tribunal. The second case I want to talk about is Kin versus Toronto Standard Condominium Corporation number 2885, which is also relatively hot off the press. It was released on February 20th. Now, this is a situation involving an owner and a guest of an owner who was alleged to participate in some breaches of the governing documents. It had gone on for a little while. There's some entertaining descriptions in the decision around the guest allegedly walking around common elements wearing only shorts and an ankle monitor and sleeping under stairwells with a pillow and that type of thing. But the key incident, as I understand it, for the chargeback had to do with the individual using visitor parking to paint their vehicle. If I have it right, it was the rims on their car that they were painting. And in the course of doing that, they spilled paint in the parking spot. So the condominium corporation charged back the owner for the cost of pressure washing the parking spot to remove the paint and the cost of a legal letter that was sent to the owner about this, a total of $892.70. The governing documents of the condominium corporation did have indemnity provisions, and the tribunal found that it was reasonable in the circumstance for the condominium corporation to charge back for both for the pressure wash and for the legal letter. Additionally, based on the situation, the tribunal also awarded the condominium $5,000 of costs back. Based on the evidence, the corporation was found to have gone to great lengths to resolve the issue. The first step that was taken in this matter was not lawyering up. The first steps were communicating with the owner, communicating about the concerns that had predated the paint situation, ongoing management letters, attempts to address the issue, attempts to communicate with the owner to bring them into compliance and to avoid the matter from escalating. Ultimately, It did have to escalate because the behavior continued, and because of that, the condominium was found to be reasonable. A direct quote from the decision and the award of costs of $5,000 and justifying the chargeback of $892.70 is that it would be unfair that the other owners of the corporation bear the complete cost of defending this application. It was not reasonable to force the corporation to incur costs to defend against the allegation of unreasonable enforcement. So the owner was trying to suggest in the course of the hearing that the legal letter was the first resort of the condominium corporation, and the evidence was abundantly clear that that was not the case. The corporation tried to collaborate and escalated appropriately because it had to.
Mark, I noticed in this last case that counsel for the successful condominium corporation was none other than Natalia Polis, who's on our panel today. Natalia, do you have any insight on this great win for you in the condominium corporation?
Yeah, so this case honestly was a textbook example of what managers and boards and corporations should do when faced with these types of enforcement and compliance issues. In this case, I think the reason why the corporation was so successful is that from the outset of when these issues first started arising with the owner and the owner's visitor, the corporation sent notices to the owner, very detailed notices providing the date, time, photos, description of what the non-compliance was, including attaching the incident reports themselves. And they referenced the provisions in the governing documents that they were breaching, and they requested compliance. And there were multiple communications from management to that effect with that great amount of detail in them. And the manager went so far in this case as to even meet with the owner to hear the owner out and try to come to some sort of resolution before legal counsel even got involved. So for me, when I received this compliance matter and I looked at all the documentation, I was like, wow, this is fantastic. The amount of detail and the amount of opportunities that were provided by the corporation before even us getting involved with it. So again, this is a situation where providing the notice, providing details, providing an explanation as to why this is inappropriate behavior, why this is in breach of the governing documents, and taking those reasonable steps to try to obtain compliance before ever getting legal counsel involved and incurring those costs. I think that's what set this case apart from a lot of others where, unfortunately, there might be someone that has a history of non-compliance with other issues, and the board wants to just go straight to legal on it and take those enforcement steps. So I think, again, it's important to have that evidence and documentation, provide those opportunities, and act reasonably with the unit owner, and give them opportunities. Give them opportunities to comply before you do send that file over to legal.
Amazing. Mark, do you have any other comments on that before we move to?
No, that's great. It's just nice to be able to have the benefit of somebody who is directly involved in the case to be able to add to this. So thank you very much, Natalia.
Wonderful.
Okay.
Okay, so we have a few minutes remaining. I hope that my screen stops sharing there. So we'll move on to some questions. I know some were posted in the chat, but we'll start with the Q&A. This is a tough one, and Natalia, I think it's for you, but what chargebacks are lienable and what cannot be liened?
So that's a very loaded question and very fact specific. So it really honestly depends. It depends, one, on what are you trying to charge back? Is it as like an insurance issue? Is it legal fees from a compliance matter? What do your governing documents say? So it's important, especially in compliance issues, to ensure that you have that you have that indemnification provisions that allow you to charge back solicitor fees for these types of compliance issues. I know everyone talks about the Emlani case, where there was a decision that you need a court order or a CAT order to charge back these costs. But we have been seeing more of a shift, at least in my opinion, of allowing corporations to charge back these costs and holding that these are valid chargebacks without having to go to court and get a court order. So again, reviewing your governing documents, make sure you have those indemnification provisions that allow you to charge back these costs. And that will really make a difference and potentially answer the question, is it lienable?
Yeah. So on that point, we have a couple questions and comments relating to Mark's presentation, about charging back legal costs when the corporation's lawyer has to be involved, despite all the efforts that the condominium corporation has taken to try to resolve improper behavior. So I have a question here that says, after 3 warning letters to an owner who is breaking a condo's rules, management has the corporation's lawyer write a letter to the owner. The corporation does a chargeback on the cost of the lawyer letter. Are you saying that we need a court or CAT ruling to issue that chargeback?
From the case law, I'm saying yes, but there are possibilities of legal opinions saying no. So I would say follow the advice of your lawyer as to what's appropriate or not.
Yeah. And I know that I don't know if Sonia wants us to read her comments aloud, but I know that there are certainly differing opinions amongst lawyers as to the application of case law and what is good law and what is not. So I think that's a great point. Mark, in every case, consult your lawyer because that is the legal advice that you, as a condominium corporation, as a board of directors, and as a manager, should be relying on. Here's a question that says, what if, I imagine it's talking about insurance. So what if they own the failed item, but they argue there was no way to know whether or not it needed to be maintained until failure? So Natalia, I would surmise that this has to do with an act or omission, in which case the failed item in question falls within the unit's maintenance and repair responsibility. And this is something we see a lot with, let's say, a pipe that's located behind a wall, but which falls within the maintenance and repair responsibility of a unit owner.
Yeah, and we do see this very frequently, and this is a very difficult situation because as unit owners should, although unfortunately it's not always the case, be apprised and be aware as to what they are responsible for. And that includes reviewing in detail the declaration. And so in these circumstances where there is something that may be behind a wall that the unit owner didn't know they have to maintain and it causes a flood, it's important to get, again, an expert opinion as to, was this a failure of the unit owner to maintain this component? And then also taking in a little bit of a more human aspect and human consideration on this. In these certain circumstances, you may have a situation where, well, the unit owner had absolutely no idea that they were responsible for this, although it doesn't excuse them. You may want to think about, okay, instead of charging back 100% of these costs, because it is an issue where you arguably you wouldn't know, consider being a little bit more lenient with it.
Is there ever a scenario where a condo can charge back for costs incurred to repair a unit below the source, even if the cost would be associated with repairing the portion that forms part of the standard unit bylaw?
So I think that is exactly why an insurance deductible bylaw is important, because without an insurance deductible bylaw, you cannot charge back the cost of repairing a unit below a source unit that was damaged in an insurable event, or for instance, the common elements. But if you have an insurance deductible bylaw or insurance deductible provisions in your existing bylaws that extend those circumstances, that's the situation where you can charge back those costs to the source unit.
We're running out of time, so we'll just take a couple more if we can. If damage is caused by an owner in their own unit, such as floor damage, and the owner doesn't want to fix it, what does a corporation do in that situation? And I think this question has to be qualified by 2 parts. The flooring is part of the standard unit repairs, and the flooring is not part of the standard unit repairs.
Yeah, so if flooring is part of the standard unit, then the corporation would repair the flooring. If the flooring is not part of the standard unit and it's something that the unit owner is responsible for and they're refusing to do so, there's obviously then concerns about mold and different like safety issues regarding letting this soaking floor exist. So in that case, typically you have provisions in the declaration, I believe also in the Condo Act, which the corporation could make those repairs after providing notice to the owner that you have to make those repairs because it's your responsibility, and then charge back those costs.
Okay, so we are closing in on 2 o'clock, and I know there's still some other questions, so we won't be able to get to them today, but I just want to thank all our presenters for this amazing presentation on chargebacks and for everyone attending. Just as a reminder, this session has been approved by the CMRAO for 1 credit. The registration list will be sent directly to the CMRAO, so you will not receive or need a separate certificate. If you have not registered for the upcoming CAI Canada annual conference taking place on Tuesday, April 14th at Parkview Manor, I encourage you to do so, and you can sign up at caicanada.com. This session is also recorded and will be posted on the CAI Canada website by the end of this week. So thank you all for attending and for participating. I hope you have a wonderful day and hope to see you again soon. Take care, everyone.
Thank you.
Everyone.